top 50 hospitality cases, 21 and 22. You're going to see Karen's bio here and take a look at that. But let me just say to you guys that Karen and her, well, I want to call her her partner in these programs, Diana Barber, also a Marshall recipient, as is Karen. But I just want you guys to understand how much time and energy they put into developing this list and briefing these cases. And we have every one of them archived on HospitalityLawyer.com. So, and all of you that come to the conferences, you get access to that each year. So I just want to remind you of access to that archive. But Karen, Diana, I think Diana's listening in today. I just want to say thank you for all of us for the work that you put into developing these presentations. Not to mention they're just delightful to listen to. So now to her formal bio. As you can see, she is a columnist, Hotel Management Magazine, but she's also the author of Hotel, Restaurant, and Travel Law, a Preventative Approach, published by Kendall Hunt, now in its 9th edition. And the previous author of that book was Anthony Marshall, along with a few other folks. So his legacy lives on, and it's a tremendous book if you want a great resource. And she's also, as I mentioned yesterday, she's her honor as she is a part-time municipal judge up in the Buffalo, New York area. Please welcome Karen Morris.
Thank you. Good morning, all. Thank you, Steve. And thanks for the shout out to Diana. I was going to do that, but hello, Diana, who usually does this with me, but couldn't make it to Dallas this year. So what we're going to do this morning is take a journey together through many cases. You will receive the paper that it will come with the materials that you're going to get from Hospitality Lawyer. It has a synopsis of 52 cases. I call it a Baker's 50. And the methodology of putting that together is to go into Westlaw, look at all of the cases since the last time I looked that have in the title either restaurant or hotel. The paper is, in the order that I'll go in this morning, is alphabetical by the topic. So if the order seems a little odd, it's by alphabetical by the topic. The ones that I'm going to review today, if we get through them, there's about 15. To decide which ones to review, I look at the most interesting or ones with a new twist or ones that advance a trend or sometimes even reinforce a well-worn rule that has a new application. Several you'll see touch on issues that we addressed yesterday, but have a different emphasis, so I have chosen to keep them in. So with that, we will go to the first case. And the title of the case and the site and the number that correlates to the paper are all on the PowerPoint, so I won't take time to give the name of the case. But this case involved attorney's fees. So the underlying case was a successful ADA case, Americans with Disabilities Act. It had to do with the website, deficiencies in the hotel's website. And the prevailing party was indeed the plaintiff, and the plaintiff sought attorney's fees and the court gave attorney's fees. But the amount of the attorney's fees was what was interesting in this case. The lawyers submitted their report seeking $425 an hour. The case, it turns out, involved a default judgment. The hotel did not participate. And so the court, or not and so, but the court reduced that hourly wage from $425 to $350 and said the court, it was a fairly complicated case to initiate, but decidedly simple to litigate. The case lays out 12 factors that courts consider. So if you're wondering how to calculate attorney's fees, that is a good case to look at. I would say this, it's a New York case, but in calculating the amount, it was not a New York City case. It was an upstate case, but including Albany, which was the capital of the state, and that is a fairly sophisticated legal community. So again, from 425 to 350. The next case, an interesting one, but they were all to me interesting. This one involved a condominium hotel, and plaintiffs were the owners of individual villas in the resort, the resort that Omni owned. And the villa owners sued for breach of contract, breach of fiduciary relationship, and RICO. It turns out that there was a broker that by contract was assigned to rent out the villas that owners wanted to rent out, and that included about 98% of the villa owners. The arrangement was set up that this certain brokerage would do it, not Omni, in order to avoid any conflict of interest that Omni would have. Well, it turns out the brokerage basically abdicated to Omni, and Omni gave preference to people who wanted to rent to the rooms, the hotel rooms, as opposed to the villas that the owners were trying to rent. So again, the lawsuit sought breach of contract, breach of fiduciary relationship, and RICO. The brokerage company sought a motion to dismiss on all three charges, and the court denied the motion to dismiss on all three charges. The court noted that indeed that contract was set up to avoid the Omni having the opportunity to rent its units first. On the issue of fiduciary duty, the court said, indeed, the brokerage company was an agent of the villa owners charged with maximizing rental revenue, and they breached that, or they did not get their motion to dismiss granted on that issue. And on RICO, interesting, the court noted that plaintiffs alleged extensive use of mail and wires to perpetuate Omni's self-dealing, particularly monthly mailings to the villa owners, presumably advising them of the status of their rentals, and using wires to transfer the money from the rentals. And that was over a 6-year period. And the court said that the plaintiffs sufficiently pleaded racketeering activity as required by RICO. Okay, so next case. This involved discrimination based on gender. It was an interesting case having to do with comparisons. So the plaintiff was a food and beverage director. She was female. She claimed she was paid less than her male counterparts. She used as comparators her 3 predecessors and also 3 food and beverage directors at other hotels, all within, and this was another Omni case, all within the Omni organization. The court said, yes, her 3 predecessors were good comparisons, but said not so for those other 3 at other facilities, that though the job descriptions had similarities, there were significant differences, including the education and experience qualifications required for the job, who the director reported to. In those other cases, that food and beverage director reported to the hotel's general manager, whereas at plaintiff's facilities, she reported to the director of operations. Also differentials were the number of food outlets at the hotels and the number of employees that the food and beverage director oversaw. And so the court said, well, the job descriptions had common denominators. All the responsibilities, complexities, and nuances of each hotel cannot be included in the job description. And therefore, the job description doesn't tell the whole story. So she was not able to use those directors from other hotels as comparators in her case. Next case involves a discrimination on the basis of national origin. I love this case because it reinforces a rule that we all know and love, and that is plaintiff has to show more in a discrimination case than that plaintiff is of a minority. Plaintiff has to be able to show evidence of discrimination based on the grounds that plaintiff is claiming. So in this case, plaintiff was terminated after 18 years. She worked as a server and then in the gift shop. She had numerous job performance evaluations that identified various problems, including other difficulty with coworkers, other negative work behaviors, and speaking a foreign language when that was not permitted by company policy. She sued claiming that she was Russian and that therefore she was discriminated based on national origin. Perhaps today, rather than a year ago, might have a little louder basis, but there was nothing here. She admitted that she had no knowledge of anyone at the hotel saying anything derogatory about Russia or Russians. And so this case just reinforces that being minority is not a ticket to freedom from termination for cause. So the plaintiff, if claiming discrimination, must in the first instance make out that prima facie case of discrimination, not enough that they're just a minority. There was another case, and don't flip, because this one I hadn't intended to use, but related. In this case, it was a manager at the defendant restaurant sued based on religion and gender. This will be number 13 in your paper that you will get. There was one incident only, a single incident where the owner of the restaurant threw plaintiff's Bible in the garbage. Presumably, plaintiff might have been reading it during work hours. And the manager told the worker that it was bad luck. Clearly not conduct that we'd want any of our managers to undertake, but nonetheless, not enough for a prima facie case of discrimination, and that case was dismissed. Next case. This one involved discrimination based on pregnancy. Here, the plaintiff was employed for 13 years at the hotel as the chief operating officer. She was not only an employee of her boss, but friendly with her boss. And over the years, they would go out together. The boss commented to the plaintiff that she didn't like workers who got pregnant. So 13 years down the road, our plaintiff gets pregnant. She reports that to her boss. 5 days later, she is terminated. She sued and she was terminated. She was given no explanation, not orally, not in writing. She never had a bad review. She sued based on discrimination based on pregnancy, said the court. The short-tempered temporal proximity between the time she disclosed her pregnancy and her termination, only 5 days, more than suffices to establish an inference of unlawful discrimination. So that was that matter. Next case. This is a ADA case, but with a very different twist than was discussed yesterday, though he might have, the lawyer who addressed this issue, unfortunately, had to go in the middle of his presentation. He might have gotten to this case, but I've kept it in because it's a different twist. So this was a complaint about the disability information on the website. Here, the plaintiff was in a wheelchair and was hard of hearing, went to the website, and here's what he found. The website says that the hotel was built in 1907, that it states that the hotel lacks an elevator, though it's on the 3rd and 4th floor of the building, and that it's not accessible for persons with mobility disabilities. So the plaintiff sued, and as the court said, put in a boilerplate complaint claiming that the website was insufficient. And here's what the court said. A plaintiff's contention in his boilerplate complaint that the website does not provide sufficient information for him to determine whether any of the guest rooms will work for him is demonstrably inaccurate. The website does, and the hotel would not, and dismiss the case. I wonder if this would be a case for frivolous lawsuit sanctions. But that was not discussed in the case. And of course, as we learned yesterday, if we didn't already know, the website must describe accessible features in sufficient detail to reasonably permit disabled people to assess independently the suitability of the rooms. Interesting, there was one factor in this case and in many of the other website cases that's worth just a moment of mentioning, and that is this website also included an invitation to contact hotel or reservation service if questions arise concerning accessibility specifics. So that goes a long way in my reading of the cases, a reference like that to discouraging lawsuits involving insufficiency of the websites for disabled folks. Next case. This was by the Texas Restaurant Association. Is there anybody here that's affiliated? Great, maybe you want to add after I discuss this. So the plaintiff had challenged the new dual jobs rule effective on December 28th of 21. So that used to be the rule for a long time has been 2080. As long as our workers, tipped workers, are not doing more than 20% of non-tipped activity, the owner, the restaurant can take the tip credit. That 2080 was, some would say clarified, some would say made more ambiguous with this new rule that tops the non-tipped work at a 30-minute limitation. Plaintiff, in this case, sought a nationwide preliminary injunction to prohibit enforcement of the rule. The plaintiff claimed that the rule is unworkable, and burdensome. The court ruled that the court denied the preliminary injunction, saying that the plaintiff did not give particular specifics to prove that imminent harm. Instead, all that was there was generalizations about harm to the members of the organization, wholly uncredible, said the court, about the comments about the claims of the Restaurant Association, and said they were unsupported and pure conjecture, clearly insufficient for the rather high bar to obtain a preliminary injunction. Let me ask if there's anything you want to add or comment.
Well, unofficially, because I can't speak for the organization, but we're very disappointed. How about that?
Yeah, I'm sure, yes.
To put it mildly.
Of course it's conjecture. We don't know exactly how it's going to play out on a day-to-day basis, but to cap that stuff at 30 minutes is totally unworkable. I mean, if you're rolling silverware for 30 minutes, but you're on a 8-hour shift and that's your 80-20, then you're not 80-20 anymore.
Great. And there are probably many restaurants that were grateful to you for bringing the issue, and maybe as it unfolds more, a second try at it could be successful. But clearly the court wanted more detailed information for the preliminary injunction. Okay, thank you for adding that. Next case. This is, boy, a Fair Labor Standards Act case with everything. The employer did everything wrong. It was a Japanese restaurant in New York City. The delivery, the folks who make deliveries of the food on their bicycles were the ones who sued. They claimed non-payment of overtime, non-payment of minimum wage, inappropriate use of the tip credit, and no notice given to workers of the tip credit, which is a rule that is strictly construed by the courts that need to give notice, and record-keeping violations, failing to pay for the delivery workers' bicycles or repairs. The first issue in the case was interstate commerce. Did the restaurant engage in interstate commerce, because it was a federal case? And without a lot of detail, the court said if this restaurant has more than $500,000 in annual sales, it couldn't have done that without using materials that originated from outside the state. So that alone was sufficient for the court to establish the interstate commerce. The defendant argued that a minimum wage poster that was displayed at the restaurant was sufficient notice to workers that the restaurant intended to take the tip credit. The court said, nope, not sufficient. A very detailed notice, it's an exacting requirement and must be provided. The defendant restaurant said that he paid overtime pay, and the court said a conclusory statement is not enough. The restaurant didn't have records, and the court ultimately granted summary judgment for the workers on virtually all of the claims. On the minimum wage, overtime, tools of the trade, that was an issue that the restaurant was not paying for the bicycles and the charges to upkeep the bicycles, the tires, the lights, the locks, and spread of hours. Cause of action was also included in this case. In New York, if you exceed 10 hours, if an employee exceeds 10 hours in a day, that employee is entitled to 1 additional hour of pay. Interesting, liquidated damages. So the Fair Labor Standards Act allows for liquidated damages if the wrongdoing is intentional or willful, and it's up to the district court to grant it, and when granted, it's equal to the amount of back pay. So in this case, the Fair Labor, the plaintiffs, the court awarded the liquidated damages in addition to all of the lost pay, noting that this restaurateur had 2 prior minimum wage and overtime lawsuits against it that had resulted in a judicial finding of liability. So you just gotta make sure that everybody is trained on all of those technical rules relating to pay. Technical to the restaurateur and hard to keep up, a lot of bookkeeping, but very important, of course, understandably so, to employees.
Karen, before you go to the next case, real quick, does anybody in here think that there is potentially a restaurant out there that is not involved in interstate commerce anymore? I mean, you still think that's a viable defense to any of the, yeah, Andrea, no? Yeah, David? Yeah, exactly. Yeah. Yeah. Yeah, David always puts a fine point on things, and we're always appreciative of it. Thanks for answering that question. That was pretty succinct. Okay, thank you. Yeah, I'm like, really? Anyway, I was just curious why they would do that, but
Well,
argue
I
that.
think given this is a defendant who was very non-compliant and of course
Yeah.
was looking for a way
Any
out.
out, yeah.
And it was an independent New York City restaurant. So some of those are relatively small, but the court said, we're not even going into detail, 500,000 in sales, you've got something coming in from out of state,
Yeah.
enough to give us jurisdiction. Great. Okay, next one is interesting. Sous chef, this particular restaurant was claiming that the sous chef was an executive employee and therefore not paying overtime. The sous chef apparently wasn't happy and sued. And the court held in the end that the sous chef was not an executive employee. Here's what, what sous chefs do may vary a bit from restaurant to restaurant. So here's what this sous chef did and didn't do. The sous chef's primary duties at this restaurant were to supervise line cooks, so it's supervisory oversight, manage the kitchen while working under the executive chef, and run the kitchen when the executive chef is absent. Here's what the sous chef did not do. The sous chef does not create the menu, order ingredients, or participate in the overall management and operation of the restaurant. He is paid by the hour. This is really the key. Paid by the hour, and his pay is reduced when he leaves a shift early or takes vacation time. The court said, no, this is this sous chef is not an executive employee, And further, the court ruled that the violation was willful here and awarded those liquidated damages. So sous chefs, look, if you're thinking of them as an executive employee, look carefully at what they are and are not doing. Great, okay, next matter is, this is another service fee case. We see a lot of these. So this was New York. A service fee is a gratuity and must go to the workers. Here, it was a banquet service fee. It was charged and only part of it was distributed to the service workers. They were not happy. This and the next case go to this issue of joint employer. Whether the franchisor is liable for the acts of the franchisee. Here, it was not only the particular restaurant that was sued, but Embassy Suites Franchise LLC and Hilton Franchise Holding LLC. Both sought a motion to dismiss, and the court denied that motion. And the court looked at what exactly the control was that the franchisors had. And the court noted that the management training, which was dictated or by the franchisor, mandated by the defendant, requires managers to assert control over working conditions. Additionally, the franchisors require franchisees to use particular hardware, mandates particular training and standards of operation and workers' appearance, and requires franchisees to conform to all laws and regulations applicable to hotels. Embassy Suite in particular required use by franchisees of proprietary property software that addresses management programs, quality control, and more. And again, the court denied the motion to dismiss for those franchisors. The next one is also an issue with liability by the franchisor for acts of franchisee, but went the other way. For probably you will find good grounds, but there's some great language in here about separation of franchisors and franchisees. The case involved Hardee's, and plaintiff was a sad case, a minor child and touched an exposed electric wire while playing at a Hardee's restaurant in their indoor playground and was killed. And now the family is bringing the lawsuit against Hardee's and against several layers of franchisor, and then the company that owns the franchisor, and the company that owns the company that owns the franchisor. And all of those companies sought dismissal. The court here said, the touchstone for liability is whether the defendant has control or the right to control the conduct of the franchisee. The court distinguished, and this is really important, this is a great distinction. The court distinguished between the right to control a franchisee and, on the other hand, the franchisor's legitimate right to ensure the property is in compliance with system standards. Said the court, this latter right of the franchisor does not provide a basis for finding the existence of an agency relationship. Let me add two things. One, playgrounds are not a standard feature of Hardee's. The franchisor can include it at their option. The court said two other things. Indeed, the entire purpose of franchise laws is to separate the franchisor from the day-to-day operation of the actual business, which is the duty of the franchisee. Here's an additional quote that is helpful, I think. At most, the franchisor agreements reserve to defendants the right to, and this is what they reserve, which is substantial, the right to conduct inspections, require management training, enforce brand standards, and terminate the agreement upon finding of noncompliance. said the court, such a reservation of rights does not provide sufficient control over the franchisee's operation as to impose direct or vicarious liability. So a good case for separation of the two, to some extent fighting the trend towards otherwise. Next case. So there were a number of these sad cases where restaurants who've been paying on insurance to cover business losses were not entitled to collect because the policy said there needed to be physical loss or damage. We saw that yesterday. I just want to point out, lawyers and restaurateurs also got clever as these cases started coming down and tried to make other arguments to fit into the wording of this, the policy. One restaurant claimed that what the orders from the governors required them to do constituted property damage, that they had to install plexiglass separations, they had to rearrange the tables, they had to enforce social distancing, and that really constituted a property loss or property damage. The court did not accept that. There was another case where the plaintiff claimed that the insurance agent did not explain well enough what was and was not included. And the court said that the court rejected this argument, noting that the average layperson would correctly understand coverage for physical loss or damage, that it requires physical loss or damage to property. So clever as lawyers are, but didn't save the day for those with that business loss insurance, alas. Next case. It seems there's always somebody who's injured in the bathrooms of hotel rooms, so I like to include one of these cases. This is a great case for the hotel. Unfortunately, the plaintiff fell in the bathtub. The bath mat slipped, I guess, underneath her feet while she was in the tub, and she fell and she hurt herself. She sued. All that she had as evidence was what the court called speculation, that the hotel staff failed to secure the mat properly and securely. That was all she had. She had no further proof. Plaintiff has the burden of proof in negligence cases. Plaintiff fell short and the case was dismissed. The next one is the lowly wet floor sign saved the day here. It was an open and obvious case. The plaintiff tripped and fell at another Omni hotel, sued for compensation. Minutes prior to the fall, a hotel employee had mopped the floor, but put 4 of these signs around. And in effect, the court said open and obvious, the plaintiff should have seen the signs and noted the problem and been more careful, and the case was dismissed. Okay, next case. This one grew out of the pandemic. I think it's such an interesting case. I love contract interpretation cases. I love the creativity of both sides in explaining or trying to explain what the terminology meant, and the reminder as lawyers to be as clear as possible. So this case involved the sale and purchase of 15 hotel properties. And the contract was entered prior to the pandemic, and closing was to occur after partway through the pandemic, which of course, and critical to this, nobody foresaw. So the contract had what's called, I guess, an ordinary course covenant. So it required the plaintiff to continue operating the business in the ordinary course for that interim period prior to the closing. Pandemic occurs. The term also said if there was any deviation from operating in the ordinary course, then the seller was to consult the buyer. So along comes the pandemic, the restaurant is closed, services at some of the hotels of the 15 were closed, services at others were contracted, many employees were dismissed. The buyer was never consulted. So now seller wants to go forward with the deal. Buyer, pandemic, all of the changes, says, not interested anymore, and wanted to cancel the deal. So they said, seller, you should have consulted us. Closing the restaurants and consolidating and letting those employees go is not operations in the ordinary course. And the seller said, well, when we're in a pandemic, it is the ordinary course. Look around, other restaurants, other hotels were doing the same thing. And the court said, no, this was not running those restaurants in the ordinary course. And of course, both had good arguments why ordinary course favored what they did. And the court said, at the very least, the seller should have consulted the buyer. And so the court ruled that the seller breached the contract, and that excused the buyer from the obligation to purchase, to satisfy its obligations in the contract to purchase those 15 restaurants. Two more. One is sex trafficking. And again, we heard about sex trafficking yesterday, and with all those, the presenter did great in terms of identifying all of those alerts that hoteliers and their staffs must be on the alert for. Here, the plaintiff was a victim of sex trafficking. She sued, claiming the hotel should know. The hotel denied liability. At first, they denied liability, saying that the trafficked woman, the plaintiff, was a licensee, and apparently in that state, little duty was owed to licensees. The hotel also argued that the criminal acts of third parties, the ones who were controlling the trafficked women, that severed any causal relationship between the hotel and the plaintiff's injury, and the hotel sought dismissal. The court rejected, not surprisingly, both of those arguments, and rejected the hotel's position that there shouldn't be liability for this sex trafficking. And so the case will proceed. Very important to train staff about those indicators, those indicia of sex trafficking, and act upon them. Last case I want to do also involves an issue that we talked about yesterday, but again, a different twist. This was a hotel that had, a restaurant rather, that had video cameras. There was a trip and fall. The policy of the restaurant was that the manager determines what parts of the video to retain, and the rest can be reused and recorded over. So in this case, the manager wasn't a lawyer and kept only the few seconds or minute leading up to and after the fall, and recorded over the rest. The manager could have anticipated a lawsuit because the guest who tripped and fell called numerous times in the weeks following the accident to indicate that she was having difficulty with the injury and she was complaining. So now fast forward, we get to the lawsuit, the discovery phase, and the plaintiff's lawyer is very unhappy with the limited amount of video that was available, because the defense was that the restaurant had constructive notice of there was some food item or spillage on the floor that caused the fall. And the plaintiff was trying to show constructive notice. So the court in this case, the plaintiff argued that there should be a negative inference that that would result from the spoliation, from the non-retention of the video that would have shown how long might have shown how long that food spill was there and might have protected the restaurant. But it wasn't there, and the court held that indeed the plaintiff was entitled to that negative inference. And the gist of the charge to the jury the court allowed was this: defendant failed to prevent the destruction of potentially relevant evidence. The lost evidence may have been favorable to the plaintiff. You may choose to find it determinative. And that was, it was a less damning charge than what the plaintiff wanted, but still not good for the defendant. So when you have videos in restaurants, and they can be, of course, great evidence, you want to make sure that parties responsible for retention understand the importance of different parts of that video and are given direction on what to retain and what can be let go. So with that, I hope that all the hoteliers and restaurateurs that you advise find your advice and counsel to be determinative on action they should take to avoid liability. So I think we have a couple of minutes if anybody has any questions, or maybe you were involved with some of these cases and want to add some information.
Maybe not. Karen, that is terrific. Thank you.
Thank you.